We do record this. Great. Okay. So as I said, I'm Morgan Bowers, founder and owner of Four Corners Legacy Law, the attorney here. This is for educational purposes. There's no attorney-client relationship between us. At the end, we will open this up for general questions. I ask that you do keep them general because you're being recorded. That's so we can provide the link to anybody who misses the presentation but signed up for it. Or if you need to share it with someone, you'll have the link to share it with them. There is the worksheet. The link for the worksheet is in the chat box. And if you submit it at the end, we will give you 2 free gifts for that. There are also boxes you can check on there that have free resources. Okay, we've got a lot to cover. So what you will learn today. Oh, and I just want to say this, it's a little bit strange to me. I do webinars on Zoom, but usually I give this presentation as a live presentation. So I love interaction. I can't always see the chat box while I'm managing all this technology, but I will try to keep an eye on it. It's one of the reasons I do have questions at the end. But if something comes up for you, please put it in the chat box. And I will be asking you questions as well. And that helps anybody, there are no dumb questions, right? If you have a question, somebody else probably has the same question. So please don't be afraid to ask it. Just like I said, to make sure it's not personal. Okay. So what we're going to cover today, we're going to learn why estate planning needs to matter to you, even if you don't have much money in the bank or you think you're too young. How handling your estate planning will support the growth of your family and give you peace of mind as well as them. What proper planning should cost, and what your next steps are if you want to be sure your family will be well taken care of if anything happens to you. So this is just an introduction, right? It's a very big topic, I'm sure you all know. And I'm going to touch on a lot of things because everyone's situation is different. I don't want to take a lot of time explaining things that may or may not apply to you in great detail, but I do want to cover enough topics that you can go, hey, you know, that's an issue that I might have, that I should be aware of, right? So I want to cover a lot, but I'm not going to go very into depth in any of them. That's where the one-to-one education session comes in that I mentioned in the beginning. It's called a life and legacy planning session. Excuse me. So like I said, we're sort of going to go very, very broadly, but we're not going to go too in depth. And if you do have questions after that, put them in the chat, email me later, or sign up for a session. So, okay. All right. So who am I? As I said, my name is Morgan Bowers. I own Four Corners Legacy Law. We used to be called Bowers and Del Perel, but my partner retired, and so I decided to change the name of the firm. I have been a business and estate planning lawyer for a little over 20 years. And I mostly, for the longest time, I moved up here in 2003, excuse me, primarily business attorney, but I also did estate planning. And as my clientele started growing older, I started seeing a lot of problems excuse me, with them not having succession planning, or estate plans that didn't cover everything they should. Oh, I'm very, very sorry. Excuse me for 1 second. So I started seeing a lot of problem with their plans. I also started getting a lot of younger clients coming to me with their businesses, and they all had very young children. And I started seeing a huge gap where traditional model of estate planning was not covering everything that needed to be covered for families with young children. I don't know where this frog just came from. I think the air in here is already dry for the season. Excuse me. Okay, so as I said, I started seeing problems with the traditional model of estate planning, and I started to really question whether what we were doing were serving the clients. And two of the biggest problems I saw were the gaps in the plans. The biggest gaps were, like I said, minor children, business succession, and incapacity. And so I decided to develop a model that was going to fill those gaps. One of the other things that was a huge problem was that planning for the future is something that most people know they should do, but they procrastinate. And then when something happens, it becomes too late. And what I've learned over the years is that people procrastinate for a few different reasons. The majority of non-business owners that I meet with have never met or worked with a lawyer before, right? They're intimidated. There's this whole image of a lawyer as a big, scary, know-it-all sitting behind a desk who's going to make, I don't know, make fun of you or take advantage of you. So people don't know what to ask a lawyer. They don't know what to expect. They don't know what it'll cost. They don't know what they need, and they don't even know what they don't know. And so I understand, that's very intimidating and scary. Some people also just think that they're too young and they don't need it, or they don't have enough assets, or that estate planning is only for the rich and the old. Others I've spoken with don't even know what estate planning is or what it means. So I've basically made it my mission to help families and business owners avoid the consequences that can occur from not planning. And I do this by educating them on the basics, right? I want to demystify estate planning and take the anxiety out of talking about death. There's a lot of people who are very uncomfortable talking about death, but it is a fact of life and it's something that's going to happen. So sometimes when you take the boogeyman out of the closet, right, or shine the flashlight on the monster under the bed, it becomes not so scary. And so that's one of the things that I like to do is make it something that you can talk about yourself and talk about with your family so that it isn't, there isn't so much anxiety. I've never had anyone, I've had people say, oh no, if I do an estate plan, I'm gonna die. Well, no, it's sort of like insurance. If you buy insurance, you're not gonna die or get in a car crash. I don't know, maybe it's not the greatest analogy, but but it doesn't really happen, right? So anyway, I like I said, I try to take the anxiety. I want to demystify everything, and I also want to support people to get their plans in place, get a trusted advisor place, and do it now before it's too late. So on a personal note, I don't happen to have children of my own, but I do have a very large growing bonus family of 5 children and 5 grandchildren, plus a sister, a mother with special needs, a horse, a dog. I've got a business with staff and employees who depend on me for their livelihoods. So I understand that estate planning is something you do not just for yourself. You do it for the people you love, for the people you're responsible for. So as we get started, I would like to learn a little bit more about all of you. So you can do this by raising your hands or putting it in the chat. Who here has an estate plan? Okay, so just okay. Okay, so yeah, if you could, there's a little button on the bottom that will say reactions, and you can raise your hand. And I can't see everybody. All right, so it sounds to me like, I guess put it in the chat. Let's see, you have a will that hasn't been revised in 20 years. Thank you very much. And if you do want to talk to me independently, there is a way that you can just message me. You don't have to put it in the chat for everyone to see. So thank you. Okay, great. So here's the thing. One person mentioned they have a will hasn't been revised in 20 years. Nobody else has raised their hand or put it in the chat. So you all do. Oh, there's one. There's another person who has one. Great. Thank you so much for raising your hand. All right, a few others. Now we've got the hang of it. Okay, great. So even those of you who don't have a written estate plan, you do have a plan. New York State has a plan for you. You may not like it. You may not know what it means, but New York State has a plan for you. So if you don't, all right, a lot of 20-year-old wills out there. Great. So, and I have another one. I have an old will, but no estate plan. So that is another thing that we are going to talk about tonight. What is an estate? What is an estate plan? All right. So an estate, it's your stuff. It's everything you own, your business, your investments, your pets. Pets are personal property. The clothes on your back, the stuff in your house. All of that is what an estate is. Sorry, I've got to move my pictures of you all. Okay. So what is an estate plan? Okay. All right, great. Sorry, just checking the chat there. So what is an estate plan? An estate plan typically refers to the legal documents that are created to manage your affairs if you become incapacitated or when you die. And we're going to go through just what those legal documents are in a few minutes. So essentially, it's the process of making sure that your family, your business, whatever, aren't left with a mess if something happens to you. So even if it's written, you may think you've got one that's in place because you did meet with that lawyer, paid a few $1,000s, and you figured it may be taken care of. But as we've already heard, there are a lot of people out there with older plans. And so a lot of times those plans, they may have worked when you first did them, but your life has probably changed pretty significantly in the last 20 years. So things to consider as we proceed. If you became incapacitated or died tomorrow, what would happen to your family? Would your income continue? If it didn't, would that leave your family at risk? Would your family be stuck in court or conflict with each other over your care or your assets? Would your family know what to do and where to turn? And if you have kids, do you know what would happen to them? So because of all these things, I'm not really a big fan of the term estate planning or even the regular process of it, because that traditional form, which is focused just on the legal documents, it leaves out a whole big part of what it actually takes for those documents to work. And that's the plan, right? So this leads to big messes, failed plans. It leads to people whose loved ones are lost, confused, or in grief when something happens to them. And it pretty much ensures that your family will have to go to court, because whether you have a will or not, court is where you're going to end up if you don't have a bigger overall plan. So I prefer the term life and legacy planning because it does include the legal documents, but it's more than that. It's a proactive plan, like a whole plan that we support you to create, and it's going to leave your family and your loved ones with clarity, a trusted advisor to support them to make the wise decisions when they're having trouble making decisions, and the documents and guidance necessary so that if you do become incapacitated or when you die, they are going to know what to do, what you have, how to find what you have, and who to turn to. So like we said, or like I said earlier, you do it for them. It's not simply for you, but you're going to end up benefiting in so many ways, because when you clean up the mess during your lifetime, you're really giving them a gift. So if something happens to you, the last thing they need is a mess. And what they need is time to grieve, right? They need to feel your love and to feel supported and to receive guidance. And you knowing that you've got it all taken care of, and them knowing that you've got it all taken care of. It's a huge gift, that peace of mind. So, okay, so life and legacy planning is first and foremost a roadmap. I love that picture, sorry. A roadmap for the people you love once you're gone, but also in the event you become incapacitated, right? Because nobody wants to be in that situation, but you want people to know how to care for you. All right. So we'll dive into a little of the nitty gritty. I'm going to give you a short primer on what is an estate plan anyway. We've already talked about people who have and don't have them and wills. And we're going to, like I said, just touch base a little bit on all of this so that you will understand what these documents are, what they do, what some of the terms are, so that whether you work with me or you work with someone else, you're going to walk in there feeling like you know something, right? Okay. So starting out with, what is an estate? You are all more than welcome to drop into a chat box if you know what an estate is. I sort of gave it to you in the beginning. Basically, everybody has an estate. It's just your stuff, literally all of it. You could be a bag lady, unfortunately, sitting on a street corner or a park bench, and that shopping cart of stuff, that's your estate. It is not grand. It is not huge. You don't have to have a butler. It's just all your stuff. All right, so we all have one. What are the basic documents? The basic documents that usually make up a plan, or at least a traditional plan, are going to be a healthcare proxy, sometimes called a healthcare power of attorney. That's where you appoint a healthcare agent to carry out your wishes if you are unable to make healthcare and medical decisions on your own. A living will or advance directive works. That's what your proxy is going to look at, or what your agent is going to look at, about what your specific medical instructions are for end of life decisions like life support and pain management. This is only applied if you can't communicate your wishes for yourself. Okay, so those two documents usually work together, and they are about your healthcare. A financial power of attorney is where you name one or more people to handle your financial and legal affairs if you become unable to manage them on your own due to your incapacity or even your unavailability, like you're out of the country. So power of attorney is for the finance and legal, and the healthcare proxy and agent and advance directive are for your healthcare. Both of those are, well, we do it in one document for the healthcare, but those documents are effective while you're alive and they die with you, right? So they're only effective while you're living. A will or a last will and testament, same document. There's a few different names for it. That's who sets out what you want to, who you want to get all of your stuff when you die. The people who get the stuff are called the beneficiaries. The person who you want to oversee that process, who you appoint in the will, that person is called an executor. And the will does not take effect until after you die. That's really important and something that a lot of people don't understand. A will is not effective until you die. So while you can appoint guardians for your children, your minor children, if they're still minors, obviously, or appoint trustees and trusts for your children in your will, none of that becomes effective until you die. So if you just become incapacitated, a will doesn't apply at all. So that's one of those gaps I was talking about. Wills also have a lot of legal formalities to be effective. There's all sorts of ways that they have to be written, things that they have to say. So they're not always effective if something happens. It also leaves them open to challenge. Everybody's heard of will contests. Well, a lot of the will contests are because wills are a public document in the probate court, and there's just a lot of formalities, and it makes them very subject to challenge. The other document that is sometimes used in estate planning in the traditional model, that is very important, is trusts, or our trusts. Trusts offer great security because they're effective while you're alive and while you're dead. Well, after you're dead, I suppose. Okay, so there's two kinds of trusts. There are revocable trusts and irrevocable trusts. We're not going to discuss irrevocable trusts because they're a much more sophisticated estate planning tool. What they do is they transfer assets out of your ownership. And you've probably heard them mentioned if you have people in your family who are a lot older. They are used for sometimes Medicaid asset protection. They are also used for people who their estates are over, say, $6.5 million, which is the New York estate tax exemption amount, which is lower than the federal amount. You may have heard of that $13 million number, double both those numbers if you're married. So if you are over those thresholds, if your estate is over those amounts, please go note on your not purple worksheet, your purple worksheet, that you may need an irrevocable trust. The other people that sometimes use them for asset protection are people who are subject to a lot of malpractice claims. They're in a high lawsuit profession, something like that. But for the most part, a much more sophisticated planning tool. That's the most I'm going to say about them. So, revocable living trusts. They're sometimes called revocable trusts. They're sometimes called living trusts. These are the trusts that you're mostly going to hear about, and that most people are talking about. It is simply an agreement between you as the grantor, the person who puts everything in the trust, you as the trustee, the person who oversees the trust, and you as the beneficiary of the trust, the person who gets all the stuff. They're completely revocable. What that means is that you can terminate them. You can take anything in or out of them. You can cancel them. You can change the beneficiaries. You can change everything about them until you become incapacitated or you die. So they're very, very, very flexible, and they protect you during your incapacity and after you're dead. Best part, if they're done properly, they can completely avoid probate. I'm going to explain what that is in a second, but they completely avoid having to go to court. And they can also be used to protect your spouse or your children from future ex-spouses, creditors, and lawsuits. Okay, so just in case I haven't made it clear, all of these documents can be changed up until the time that you become incapacitated or you die. So very, very flexible. Some of the other gaps that we create documents for that are not part of a traditional estate plan would be a kids protection plan. This appoints long-term and short-term guardians in the event of your incapacity, because as I said, your will only covers it if you're already dead. How many of you, if you could put in the chat, have minor children, or you can raise your hands. And so anyone with minor children, all right. What about young adults? Because there's another gap that we sometimes get as well. Okay, so the minor children, the reason we're considering them is that practically speaking, youngish adults, okay, what would happen if your kids, if you don't make it home, right? So who's at home with them? Does that person have the legal authority? Or is what going to happen is that the cops are going to come, they're going to call Child Protective Services, and they're going to be in the care of Child Protective Services until somebody with legal authority is either appointed by the court or has a document. Okay, so if you do have minor children at home and you have never appointed long-term or short-term guardians in a document other than your will, which won't work, as I said, please note that on the worksheet. We have a free resource, because I feel so strongly about this, that we have a free resource we can send to you that will allow you to get those provisions in place, even if, again, you decide not to work with me. The link is on the website, and I will ask Laura now to drop that into the chat in case anybody needs it, or you can always email us. So the young adults, I see a few people here with young adults. When a kid goes to college, parents can't get access to their medical records or make their medical decisions if you don't have something in writing on file. So a lot of times we suggest get a healthcare directive, advanced directive, healthcare proxy, and a power of attorney in place for them. especially if they're not married, you may want to get those kind of documents into place for your young adult children. So you can also mark that. There should be somewhere on your worksheet, but if not, just I need planning for my young adults. 27, yes, we all still consider them young. If they're married or have a significant other, they should probably have something in place for that person to take care of them, or you. There's nothing wrong with that. Okay, so what's left open? Where you might be unconsciously at risk. You have no plan at all, or it's been 3 years since you've had an update to that plan, right? Life changes a lot, especially if you have young children. No ongoing relationship with a lawyer. Those of you who have wills or an estate plan, when was the last time you talked with that lawyer? Do they know what's going on in your life? What changes have happened with your family or your assets? No coordinated planning between generations. Do your parents have an estate plan? And have you spoken to them about what's going to happen? For those of you who have older children, have you talked with the older children about what's going on in their lives, and where intergenerational planning, there's a lot of valuable opportunities for a lifetime of asset protection that you can give to them, or your parents can give to you, that you could never create for yourself, or at least not create without a huge expense. Also, no up-to-date inventory of assets. More than $58 billion is sitting in the Department of Unclaimed Properties across the country here in the United States. I think it's 17 billion just in New York State alone. Where are your assets? Who knows how to find them? Who knows how to access them? Another one would be, do you own property outside of New York State? If you own property outside of New York State, you're guaranteed to have to go to 2 probates, not just one. Well, your family will. Why? Because we have to do what's called an ancillary probate in every state where you have property. Okay. So we're going to move to that. What happens without planning? If you become incapacitated without a proper healthcare proxy or advance directive in place, your family might have to go to court to access your medical records and make decisions for you. They may have to go to court to be appointed your guardian, either of your person to make those healthcare decisions, or of your property, so that they can access your finances to take care of you and to take care of your financial obligations. If you have a business, they may have to go to court. Your business partners may have to go to court to access and run your business, as well as your family. So what does this mean? This means that the wrong people could end up making decisions for you. For example, a soon-to-be ex-spouse, they're the ones who have the right until you're divorced to make those decisions. Or it could be a parent when you prefer your friends. There's just, your family better than I do, but those are some of the things that we explore. Decisions could also be made that are not in alignment with what you would want, the type of care you would want, where you would want to be cared for. It's also a very time-consuming and expensive process to have to go to court to have these positions appointed, as well as if a financial guardian has to be appointed, they're going to have to go back to court every time they need to expend money on your behalf. So not having planning, if you become incapacitated, can be expensive, time-consuming, and your wishes may not be carried out, and the wrong people may be making those decisions. Based on my earlier question, I was going to ask you now, how many of you here have a revocable trust already, or an irrevocable trust? And if you do have a trust, can you also drop in whether or not you have funded the trust? So what funding means, funding a trust, means transferring your assets into it, naming your trust as the beneficiary, retitling your account. It's a fancy term for making sure that all your assets are in your trust. And I'm not seeing any hands or anything yet in the chat, so I'm going to assume Okay, great. So I'm seeing at least a few people who don't have trusts. So if you die with a will and with no trust, as I said before, the state has a plan for you. And okay, thank you. And what that plan is, uh, depends on your family situation, but generally speaking, if you have a spouse, your spouse is going to be the person to administer. And by the way, this goes for if you die with without a will or with a will, the process is just different. One's called probate if you have a will. The other is called administration. If you don't need to know the technicalities. The process is the same. But if you don't have a will, New York State's plan is your spouse and your children are going to get 50-50 each, whether or not your children are minors. So if your children are minors and you have no will and no trust, your minor child is going to inherit 50% of everything, and a guardian is going to have to be appointed by the court. And this guardian is not necessarily going to be your current spouse. And even if it is, they still have to go to court just like anybody else would to get things approved. So it generally goes spouse and children, adult children if there's no spouse, spouse if there's no children, then it goes up to your parents. If your parents are passed, it's going to go down to your siblings, then down to nieces and nephews, and there's a whole little waterfall. So these are the people who would have the right to make decisions and who would be inheriting if you don't have a will. If you die with only a will and no trust, everything that does not pass automatically, and things that would pass automatically would be joint bank accounts or property owned with a right of survivorship, or where a proper beneficiary designation has been done. All of those things will go outside the probate, but everything else is still going to have to go through that court process. What's wrong with that court process? It takes a lot of time. Here in Columbia County, if most of you live in Columbia County, we are a really fast county. Still takes 2 or 3 months just to get the person appointed. And that's if everybody gets along and it's a very uncomplicated situation. Everybody does what they're supposed to. You're very organized. It has to stay open for a minimum of 7 months for all the creditors to make claims against the estate. And then it usually takes a few months to close it. So you're looking at a minimum of 9 to 12 months before your family is going to have access to all of that property or anything. So if you do have a spouse who is reliant on or needs those assets in order to keep the family running, or children that need the assets to keep the family running, that money is going to be tied up. It also costs a lot to go to probate, right? Again, situation where there's no conflict, no problems, everybody does what they should, they're all organized. It usually costs, just to open and close the estate, between $5,000 and $10,000. If the lawyers needed to do all the administration in the middle and the executor wants to take their executor fees, or there's any conflicts, you're looking at well over $10,000. It's also public. You can look up anybody's will that you want, okay? Once a person dies, their will is public. Not public until they die. After they die, it's public. So everybody's going to know who your beneficiaries are. They're going to know who your executor is. They're going to know who your family is. They have access to all that information. And they do prey on people, right? There's a lot of scams out there where, because they know how much people are going to inherit, they go after them. And it's at a time when most people aren't thinking straight. It's public. Oh, I already said that part. Okay. It's also open to contest. I mentioned that earlier. Even if you have a will, it's open to contest. If you don't have a will, New York's already decided who's getting everything. So then you at least don't have a contest. All right. So I've told you all these horrible things about probate. Eek, right? How do we stay out of probate? You own all your assets that would go through probate in a trust. So if you own a home, that's a probate asset. If you have minor children, you certainly want to think about a trust in, for them. So there's a lot of situations where a trust is a really good thing. This is going to keep you out of probate. If it is updated and kept updated, and if it is fully funded. So if you are at all concerned about keeping your family out of court or out of conflict, if you become incapacitated or when you die, you can go ahead and mark on your worksheet that you want to keep your family out of court. I think that's what I don't have the worksheet in front of me, but it says something along those lines. It might say you want to avoid probate. So as I said, trusts don't work properly if assets aren't owned by the trust. So if you do have a trust, which it looks like nobody does, but you could check that box instead, that you need to make sure that all your assets are owned properly. And for those of you with a will that is outdated, you're probably going to want to take a look at that and make sure that everything is still accurate. Because if it's not, I sadly have clients less with wills. Usually if they if they get divorced, they remember to redo the wills and the divorce nullifies that. But I have a lot of people who get divorced and don't remember to change their beneficiary designations from their ex-spouse, and then their ex-spouse inherits things that they didn't mean them to. So that's never a good thing. I've got one of those right now. Okay, so how do we prevent it? Revocable living trust or living trust means the same thing. Lots of flexibility, but it does need to be accompanied by a plan. It needs to be accompanied by someone who can help guide you or your family through if you do need it because you become incapacitated, and it needs to be funded. With the trust, assets are going to go to your kids at the ages you want, or they can be fully protected from taxes, creditors, future ex-spouses, and lawsuits if you want that added protection. If you're currently married, you can also give that protection to your spouse, or your spouse can give that protection to you on their death. So there's a lot of cool things that we can do with these trusts, and they're not that hard to set up. It does require some paperwork, and it does need to be kept updated on an ongoing basis. But if it's set up right, well-maintained, works for your incapacity and not just your death, and it's going to keep everybody out of court and out of conflict, and make sure that everybody knows what to do if something happens to you. So like I said, trust enough is not the answer. You're still going to have a will, healthcare directive, and power of attorney to back it up, and also a kids protection plan if you have those minor children. So why can't you rely on form documents or cheap lawyers or the internet? AI and all these things. Everybody thinks they're a do-it-yourself Dr. Google and lawyer Google and financial planner Google and everything else, right? Everybody wants to search and find a way to do it themselves. Well, that's great if you want to spend a whole lot of time educating yourself. But in addition to a lot of the things I just identified, making sure that things are done properly, keeping them up to date. If you cheap out and try to do it yourself, or do it with a lawyer who focuses only on the forms, you're almost guaranteeing that your family is going to have a mess to clean up. I like to say one size fits all. I don't know. It looks like a lot of ladies on the call, but I'm sure men have the same issue. One size fits all usually doesn't fit anyone very well. For estate planning, clothing, right, maybe a hat. I don't know. But it's just, you don't, it's one of those things where you don't know what you don't know. So you don't know why little things, I hate to say it, but it depends, isn't a lawyer's favorite phrase, because we want it to be, but it does depend. It matters if that house that you purchased with your spouse was purchased together before you married. That actually can have a massive effect on your estate plan, right? So these are the type of things that you want someone who is going to take the time to talk about, to ask the right questions to elicit this information. Because even if a plan also that you drafted at the time, things change. It may have worked at the time, but it's designed to fail if it's at a date, right? So you want somebody who is going to help you keep that plan up to date. So what do you want your attorney to include? You want someone who's going to educate you on what will happen, what is possible, and who offers your goals and can educate you on the solutions that are going to meet your personal goals so that you can make the wise decisions that fit your goals, right? You don't want someone who's just going to say, oh, here, this is what you need, right? Without digging into all of these things. You want somebody who is going to help keep your plan updated because they're going to meet with you or at least talk to you on a regular basis, and that you feel comfortable talking to or going to on a regular basis. You're going to want somebody who's going to help you prepare and keep an inventory of assets so that your family knows where everything is and how to access it if something happens to you. You may want, we have a lot of clients who feel very strongly about passing on more than just their financial wealth. They also want to pass on some of their cultural or heritage or family traditions, right? There's a lot more to wealth than just money. A lot of it has to do with your family. So does this person that you're working with provide interviews or other ways that you can work that intergenerational wealth into things? You also want to find somebody who's going to help you get something like a kids protection plan into place. And that's, pretty much how what we do is different and why I built my practice around all of this. We want to make sure that that plan will work when you need it to work the most. So we do have that structured. Sorry, I sometimes have trouble keeping up with my own slides. But when we do these live or in person, this is live, I don't usually have slides. And so I'm just talking with people. So I don't have to worry about flipping through. Okay, so what should this cost? Definitely a topic on most people's minds. A typical death plan with a traditional attorney, and I call it a death plan because it's mostly concerned with what happens after you die. But a traditional plan with a lawyer who advertises estate planning, or you find on the internet, one of those plan here now things or hear about on the radio, you're going to spend at least, I don't know, $1,500. If it's less than that, I don't know what they can be providing you, right? They're going to meet with you for 30 to 60 minutes. They're going to say, oh, you have this, this, and this. Here's what you do. You're going to sign some documents, put them on a shelf, and probably never hear from them again. You might get a will or a power of attorney or healthcare proxy. They're not going to do a trust in that price range. Probably for a trust, you're looking at somewhere between $3,000 and $7,000. And they're going to give it to you and they're going to say, here, this isn't going to work unless you fund it. Have a nice life, make sure that it gets funded. And again, you're going to take them home. You're going to have no idea what to do with anything. Because that's all the lawyer can afford to do if they want to stay in business, right? So if you do it on the internet, probably going to cost you a heck of a lot less, but you're certainly not going to have any idea of what to do with all of this. So what we do is we meet with you in our office for the life and legacy planning session. This is that one-on-one educational meeting I talked about before. You're going to discover exactly what your family needs. So you're going to have the peace of mind to know that that plan is going to work when your family needs it most. Because during that session, you're going to tell me about your family dynamics and your assets. And then I'm going to tell you about the law and what's going to happen to what you have and to the people you love as things stand today, whether it's that outdated will or you don't have anything in place at all. And we're also going to inventory your assets so that nothing gets lost if anything happens to you. So if your plan does have holes and it's not what you want, we're going to give you solutions to what that is. And we're going to offer you some choices that meet your personal goals. So we're going to design a plan to fill those holes. And we're going to do that because you're going to tell me what works for you, what doesn't. So you're able to choose the most affordable, effective, and efficient plan. But before that session happens, you're also going to be fully prepared, because a lot of people, they get overwhelmed when they come into the session, and I need to be prepared. So we ask you to do a little bit of pre-work. We call it the homework, and it's already going to get you more financially organized than you've probably been, depending on how organized you are. You've heard of getting your affairs in order, and that's what we're going to help you do. And so, okay, so the life and legacy planning session, because it's a full 2-hour meeting, we set aside 2 hours. We go through everything you have, who you are, what, all of that. This is what is right now. And then that's the first hour. If you decide to move forward, we then go into designing the plan. That's the second hour, right? So by the time you leave that planning session, you will have designed the plan, and you will be scheduled for your signing meeting. I like to call it a procrastination prevention program, right? I mentioned procrastination is a problem at the beginning. That's how we do it. We move things along. We always say that a decision made is better than a decision not made. You can always change your mind, but if it doesn't bother you, it's probably the right decision. So that session is normally $750. But don't panic, because in a few minutes, I'm going to tell you how I'm going to give you that session for free, right? I'm also going to tell you how to get $250 off toward any planning we do together. So does anybody want to hear about that? You can raise your hands or throw it in the chat. I'm sure most people want to hear. Thank you. Great. So thank you. Good. All right. Well, I'm going to tell you how to do that. And we call that the $1,000 golden ticket. But let me get back to, so what do our plans cost? Our plans for a will-based plan, and will-based means a plan that is going to have to go through the probate court, because a will guarantees probate, and so does not having a will. Those plans start at $2,500. Our trust-based plans, and those are the staying out of probate, staying out of court, you're keeping your family out of conflict, because the other thing, if I didn't mention it, is a trust is completely private. Okay, they never get filed with the court. Nobody knows who you've picked, what you've done inside of that trust. So they're also private. Most people who do their trusts with me are in the $5,000 to $7,000 range. And within that range, there's some variety. If you have one or more businesses, or you have a blended family with children from both marriages, right? They may get a little bit more, that's where we sort of get into the upper price range. But most people are down there in the $5,000 to $7,000 range. And again, you're going to know what that fee is before you move forward, and it's all flat fees. So there's not going to be any surprises. Okay. So, okay. All right. Thank you, Laura. Laura's putting all sorts of stuff in the chat box for me. Great. So what to do if you're at risk? I'm going to make it easy for you. All of our systems and processes, and Laura is one of our human systems and processes. Laura is my client services coordinator, and she is there to help guide you through the process along with me. They're all designed to help you do the right thing and to make it as easy as possible for you to keep moving forward. Even if you want to procrastinate, put it off, not do it at all, just because it's another thing on your list, right? So because of that, if you're ready to take your next steps, that $1,000 golden ticket that I've mentioned is to support you as my gift. All I ask is that you have to be willing to do your part by making it as easy for me as possible to help you. So to get the life and legacy planning session at no charge, that $750 session for free, all you have to do is to commit to completing a bit of homework. I mentioned that before, prior to the session, turn it in prior to the session so I can review it. And both decision makers, so if you have a significant other or a spouse and you're planning together, both people need to attend that meeting. And if you can promise to do that, then you get that session for free. And the, oh, right, the $250 off. Wait, wrong slide. Oh, goodness. Okay, well, I don't know where my slide on that went, but at any rate, the $250 off is my gift to you for not procrastinating, okay? In order to get the $250 off of any planning that you want to do, you need to schedule your appointment in the next 2 days. You can schedule online, you can schedule by calling our office, you can schedule by emailing. Like I said, we try to make it real easy. You can go to our website and schedule. Just mention that you were on this webinar and the golden ticket, and you will get $250 off for that planning. That's my gift for getting you motivated and getting you moving. Okay. Oh, there it is. See, I'm sorry. I apologize. I'm just so not used to using these slides anymore. Okay. If you want to book a session after today or after the 2 days, I will still waive that life and legacy planning session. I just feel it's so important for people to get this done. But you won't get the $250 off. So you are, you're still going to get moving forward, but excuse me. But I do need to do that. Let's see, what else? Oh, I set aside a very limited number of sessions because they are 2 hours. So I only have a few sessions every month that are available. So, if you have to rebook your session, I ask for as much notice as possible unless it was an emergency. Otherwise, I do have a cancellation fee because I can't use that session for anybody else. So we usually require at least 3 days notice before you cancel. And if you reschedule, that's great. Okay, so in order to get all of these fabulous prizes, please turn in your purple worksheet by clicking submit at the bottom. Laura will be in touch with you. What is the commitment after attending the session? Great. So there is no commitment after attending while you're at the session. So what happens is we start out going through everything. If you decide not to plan after we've gone through everything, if, for example, whatever your old will is fine, or you're in intestate succession, that means you don't have a will, you're okay with that, and you say, I don't think I need to do any planning, then that's it. There's no charge. You're only going to move into the second half of the session if you decide that you don't like what's going to happen. Once we start designing the plan, that's where you've decided to retain me. And at that point, you've engaged me as your attorney. We design the plan, and you're going to come back in a few weeks to sign the plan. So at that point, yes, there is a commitment. I hope I have answered that question. I'm not saying your name just because you've done it in a direct message, so I don't want to say who it is. But if that didn't answer your question, please let me know. The other thing is if you're not sure that a 2-hour session, the life and legacy planning session, is right for you right now, you can also book a 15-minute free call with Laura or I, where we can go over. Oh, great. Oh, good. I'm glad that answered the question. We can also go over some more of this on the call. Sometimes their spouses aren't on this Zoom, so we can send you the link for them to watch, or you can get a quick call with us to talk to them if they have other questions, right? So we try to make it as easy as possible. And if you book that consultation call in the next 2 days and you book your life and legacy planning session from there, right? As long as you keep things moving, I'm still going to reward you with that $250, but it's really for people who keep moving forward. I think I covered, sorry, I'm going through. Okay. So Laura, I see, has been dropping all sorts of links into the chat. And I want to thank you all for taking time to meet with me, but I am going to open this up to Q&A sessions. We're just about at the end of the hour, but if it takes a few minutes longer, I'm okay with that. You're welcome to post them in the chat if you want to do them privately, but they are going to be public responses, so don't name names or anything specific. The booking sites are open. Let me turn off the share. And while I'm waiting, you can also raise your hand and I can unmute you. You can unmute yourself. I just want to do it in an organized manner so nobody's talking on top of themselves, but you can raise your hand. We're located in Chatham. Some questions we sometimes get are, does this have to be in person? Signing in New York for an estate plan does need to be done with witnesses and all sorts of things. So yes, we try to have the signing session in person. The planning session doesn't have to be, but I prefer it. I just think everything works so much better now that, we can meet in person. It works better in person, but we can certainly do parts of this in person. Sometimes we do a hybrid. One spouse isn't in the area. We'll sit with one spouse, put the other one on a Zoom and do it together. Not seeing any hands yet. Other questions we sometimes get: why do both people need to be there? Because I need both decision makers there. Right? Because you're going to be making decisions if we're moving forward. So both spouses, or if you're planning with significant other, need to be there. Children don't count as significant others. Some people want to plan with their children. It's usually husband and wife. Okay, wait, I'm starting to get some questions. Let me just finish that one. So some people do want their children there because they are the important person who's going to help them make decisions. That's okay to have, but you will lose some of the privilege that the communications will have. And I will at some point send them out of the room. I joined this meeting because I wanted to help my mother-in-law get organized, but I realized I need to get myself organized. Yes, that happens all the time. Thank you for saying that. Where I do get that all the time. So it's true. It's true. Okay, I have to jump off, but I'll be in touch. Well, thank you very much if you've already jumped off. I had a phone call. So what do I charge? Okay, we had mentioned that earlier. I would love it if you could listen to the whole recording because it does matter. But a will-based plan where you will absolutely be in court, because that's what a will guarantees, those start at $2,500. If you want to avoid court, or you have people to protect, like special needs children, parents who are in nursing homes, things like that, the trust-based plans usually start at $5,000 and go up from there depending on what other special things we need to add into them. There's a lot of other protections that people want. But that is the type of thing that you're going to know what it is up front, and you're only going to pick things that matter to you, right? That you have identified through our meeting are important to you. Do I do multi-generational planning in one package? So that's a yes and a no question. If you have minor children, they are going to be accounted for in that package. The planning is for you and your significant other, you and your husband, or if you're divorced, just for you. So your children will be accounted for in that package. You might be accounting for parents in that package, but do I do a plan where your parents come in, you come in, and your children come in, and everybody's having 3 different things? No, it doesn't. It just doesn't work that way. However, it gets more complicated. It would depend on, like, if you had a business and needed succession planning, but generally speaking, that type of planning isn't in one package. You're very welcome to the people signing off. Okay. Let me see. So the question about in multi-generational planning, if you want to unmute yourself, if I didn't answer the question. If I misinterpreted it, if you want to unmute yourself, you're welcome to. I'm trying to think of.
Hi, can you hear
Hi.
me? Hi,
Yes.
yeah, so I had the question about the multi-generational planning. Basically, my mother-in-law is moving to town, and as we do all that mortgage work, I'm trying to use this as an opportunity to get organized in all capacities.
Mhm.
So I'm the kind of person who thought I didn't really need a will because my business doesn't make a lot of money. I don't have a lot of money, but I do have a minor child and a spouse.
Right. So
Anyway,
don't remember, this is public and recorded, so don't
yeah,
give away too much. But
yeah, no, it's all totally fine. Yeah, so I was just kind of curious, like, yeah, I guess that was my question about the multi-generational thing. But it actually, as I say it out loud, it sounds like my situation is complicated in and of itself.
So complicated and not complicated. It's just,
Yeah.
there are things that you're going to want to consider. And what I find is a lot of people go through the process and then they're able to go back and talk to their mother-in-law or father or whoever it is.
Hmm.
Because a lot of the older generation, especially people who are first or second generation immigrants, are very hesitant to talk about estate planning and death and things like that with their children or with anybody else. So what
Hmm.
happens during the life and legacy planning session is you get so educated, you're going to figure out how to talk with them in a very non-threatening way, like, oh my God, I just had the coolest thing, right? Like, it gives you a lot of ways to have those conversations and to help them then figure out what they may or may not need, because you're going to learn how to issue spot their own issues.
Yeah. Other question while I have your attention, and I think it might be applicable to many people, is, one's primary asset is a home, but it still has a mortgage on it. How does that work necessarily as like a transferable asset?
Okay, so that of course is going to depend on your
Hmm.
particular situation. As far as transferring a home, and the easiest situation, of course, is when there's a husband and wife and you both own the home and you're both on the mortgage. There is a rule, a federal statute that says that you can transfer that home into a trust without triggering the due on sale clause of your mortgage. So whether or not your home has a mortgage, you can still transfer it into a revocable trust. Not an
Okay.
irrevocable, but a revocable trust, which is what we're talking about here. A completely separate question, which actually is a really good thing to be asking, because a lot of people may be curious about this, is, well, there's a mortgage on the home, right? So one of the things for parents of minor children or spouses that have a more traditional setup where one person's the breadwinner and one person's not, how am I going to provide enough funds for my family if something happens to me? And in New York, lawyers are not insurance brokers, but life insurance. Life insurance is one of the best ways that you can use to make sure that your family is going to be taken care of. And we build that, if you have it, or you go out and get it, we build that into your estate plan. We can help you try and figure out maybe how much you need to do this, right? But you got to find the money somewhere. So there are different ways that you can use insurance policies to make sure that that's taken care of.
Okay, excellent. Thank you.
Yeah. So I've got a question on the trust-based plans about additional fees. So no, once we pick a plan, and we discuss what it is that you want, there are no additional fees over that. Everything is disclosed, everything's completely transparent right there at the meeting up front. So like I said, you're only going to pick what you need. For the trust-based plans, one of the things that's included in that flat fee is the transfer of your non-New York City primary residence into the trust. New York City is its own beast sometimes, and co-ops and condos, those are slightly different. If you have one of those, we talk about them at the session. But anybody who's got a house in Columbia County or one of the surrounding counties, that transfer we do as part of the fee already. And that's about a $500 value, because there are filing fees that we have to pay to the court, to the county clerk to do that. So that is included in that fee. Laura said, no hidden fees. You know, like I said, I want to demystify this. I want to take the fear out of doing this. And people who haven't worked with a lawyer before have, you know, a lot of ideas about all these hidden costs and expenses. That's one of the things we really try to avoid here. I am super upfront and transparent. If you don't need a plan, I'm going to tell you that. And I'm going to say, it was so nice to meet you. And, you know, come to me if you have any questions or something changes, but congratulations, right? So that's just who I am and how I work. So if there aren't any other questions, I think we're going to start wrapping this up, but it has been such a pleasure meeting you all, or I hope to meet you all, talking with you. And, you know, please feel free to reach out. My email is Morgan, MORGEN, so Morgan with an E, at Bowers Law NY, BOWERSLAWNY.com. Laura's is Laura at BowersLawNY.com. She's always a little bit, you know, usually she fields the questions, and if she can't answer them, she sends them on to me, right? But that way, one of the other things we try to do is make sure that you get responses as quickly as possible. Our phone number is 518-392-9550. Again, you can pick up the phone, give us a call if you have a question, shoot an email. And most of this stuff, we have a lot of free resources on our website. Oh, right. I'm sorry. Laura's email is client services, client services with an S at the end. I don't even know her. Sorry about that. So yes, the library is wonderful. And I just really want to thank Thea and Deb and everybody at the library. They are always such a wonderful resource. And before I moved to Chatham, I lived in Churchtown, and the Claverick Library was my library. And so I love it dearly. And anyway, thank you all for joining us so much. Okay. Have a lovely evening.